So, ladies and gentlemen, as you did hear, this is the first time we are recording a podcast like this in front of a live audience. So, do pardon me if I'm sometimes seem to be staring away into space. I'm trying to find a camera. I will open it up to questions after about 35 minutes, and that will also be part of the podcast. Hello, everyone. Welcome to the India Story podcast. And one of the things that has been coming to bear very strongly over the last few months of recording this and trying to figure out how do you accelerate change in India is that there are certain specific areas that people believe are very tough to change. They are the chains that are holding India back. And unshackling those chains is something that people are scratching their head about. And the same issues come up. Labor, can we ever fix labor? Regulation, can we ever deregulate? And then, perhaps above all, can we ever fix our legal system? Now, the good news is that work is happening on labor codes have been notified, work is even happening on deregulation, and if some of the panels that we're hearing about can actually, their recommendations are accepted, we may well have deregulation. But the legal system, what are we going to do about the legal system? Well, as it turns out, we have some great ideas. And we have with us the man who's written an entire book on some of those ideas. And as you can see, the title is Unshackling the Elephant, because that essentially is what would happen if you were able to fix the legal system. Anand Prasad, the man who was the founder of Trilegal, went into politics, got his own firm now, been working in the legal field for a long time. Let me just first start by asking you, is it possible to fix the legal system in India?
Thank you, Vikram. And thank you, everybody, for being here this early on a weekend morning. But to answer that question, there's a very quick answer, yes. And you can fix it quite easily without being too reliant on what you think should be driven by the judges. So it could be the task of the rest of the state, which is executive and the legislature, to actually do a lot of that fixes.
So that's an interesting thing which you say, because quite often the only way people say that the legal system can be fixed is that, oh, we need to add more judges, or we need to, remove the way judges are appointed, and that's essentially it. But you're saying that the rest of the system has an important role to play also.
So that would be true if you didn't think imaginatively. Now, all of the world is moving using technology in a particular fashion. There is no reason why the legal system should not use that. So just think in very simple terms. Think of the cost of building so many courts, hiring so many judges, training them, hoping that the judges turn out to be good. As against that, you install technology systems. At a very basic level, you put in television screens, you put in great cameras, you put in speaker systems, you create rooms that are sort of easier to do business in acoustically, and you'll find these digital courtrooms, and they are so much more effective than physical courtrooms. So overall, very easy for the state to make that investment. It's not a huge amount of money. The human cost is also not as much. You can then supplement it with technology. Just think in terms of how do the BPOs work around the world. So how do you create for the lawyers? It is how do you create these know-how systems that are then giving ready and easy access to the courts and to lawyers and to everybody else, but basically to the judges, will actually also improve their quality in terms of what they do.
So using technology is one of the key elements that you have in your book. And I'm going to go like almost step by step into the many suggestions and solutions that you propose. And I'm also going to bounce off you some of the big bangs ideas that have emerged from other people. But let's first just address the extent of the problem. Because when I began by saying that the problems with the legal system are perhaps the most profound chains that are holding India back, would you agree with that? And maybe elaborate on that. What's the real extent of the problem right now?
So this will be true for all of us in this room and for people who are outside this room as well. And I'll respond to that in the manner that I respond to a client. So let's say I do have done and continue to do lots of work for international clients. And the question that you would get asked is, what do you expect of the legal system in India? And my answer very often would be, think of the legal system that you have in the UK or the US. We are exactly like that, with some small variations, but we are exactly like that. Which is true, in our textbooks, we are exactly like that. The problem is when you implement it on the ground, and it begins to resemble something very, very different. I then think of it in terms of the metaphor that I use in the book, which is a frog in a water on slow boil. So the old example is if you throw a frog in boiling water, it will jump out because it's so hot that it will die, so it jumps out. But you put a frog in normal water and you give it gentle heat, bring it to boiling temperature, the frog keeps adjusting to the increasing temperature and ultimately boils to death. It doesn't jump out. That's just a saying. There'll be debates over whether that truly happens in life, real life or not. But that's exactly what is happening in our country. We believe that we have a strong legal system. That's what our textbooks tell us. That's what our government tells us. But when we actually encounter something which you would not expect to encounter, you realize the system does not work. So easy examples. You drive out of here and you meet with a car accident. From there, you will see what a struggle it would be. So whether it is making a police complaint, carrying it further from there. And that's the truth of how laws work.
Somebody was to ask that question, and I know I've got to be careful of what I'm saying in a room packed with lawyers, essentially. So, bear with me on that. But the fact of the matter is, if anybody was to ever ask me for my advice on dealing with India, I said, make sure you never enter the legal system. 8 years, could be 10 years, could be 15 years, date after date, time after time, your matter may never be heard. The possibility of getting justice through the judicial system and the legal system in India is actually rather low. And especially if you realize that justice delayed is justice denied, you don't get quick justice in India. Am I being accurate or am I being harsh?
You are by and large being accurate. There are certain areas where India works very quickly. So let's say, and those are disruptive, let's say getting an injunction. So you want to stop something, this is a great country to be in. You can stop anything. You want to get something to happen, then you are climbing an uphill.
That's not necessarily a positive, by the way, just to add to that, So, and a cost-free injunction. So you want to hold something up, you want to get somebody into trouble, you can file a case, file an FIR, matter lasts for 9 years, you're relaxing. That
then becomes part of the problem. It is part of the solution was somebody who is, let's say there's a tenant who is being evicted unfairly by a landlord. So it's easy for him to get the landlord to stop, therefore continue. But then he then gets to continue for the next 10 years. And that's where the challenge is. It works in certain ways. In theory, it still continues to work if you take out the time. Now, one of the reasons why it takes those 10 years and why it's a nightmare once you get the injunction is for the landlord who loses a case or for a tenant who loses a case, the consequence of losing the case is very low. So I will continue to battle on because there is very little consequence. And that is what drives this behavior that says, let the case go on endlessly.
Looking at the consequences, if you really think about it, why is the problem of delay such a major problem? If you are innocent or an aggrieved party, you would like there to be quick justice, right? Because if you're innocent, you want to be proved innocent. If you're locked up in jail and you're not getting bail, you want the trial to happen, you want to be freed. You won't have the sword hanging over it. Or if you're an innocent party if you're the person who's wanting to get something done and you have a fair case, you probably want that trial to happen really quickly. If you're guilty or the person who's doing something wrong, you want justice to be delayed. Because in that much time, कोई witness को bribe कर देंगे, कुछ चला जाएगा, the system will be managed, and even if I go to jail 10 years later, who knows, something else will happen. So this present system of delay is good for somebody who is guilty and bad for somebody who's innocent, and it should be the other way around.
That's absolutely true. So let me put exactly what you said slightly differently in a business context. Let's say I borrowed 100 crores from you and I need to pay this back to you in 300 days. Come day 300, the question for me, should I give you back the 100 crores or should I tell you I will not pay you that 100 crores? Because in my mind, I do know that I have to pay you. So your options are, let me go to court, let me sue him. The case will drag on for 4-5 years. At the end of 4-5 years, the court will order saying that you give him his 100 crores and it will award what is called interest for delayed payment. It will say interest, our courts will give an 8%, 9%. That's the range at which it gives. Think of it differently. Think on day one, I paid you back the 100 crores. I then go to the market and borrow from the market. The cost of borrowing is 14, 15, 16%. Could be even higher if I buy privately. So if you are an entrepreneur and if you're a crooked business person, you will say, actually, I am better off not paying Vikram back on time because this is cheaper finance. It comes at an 8 or 9% interest rate. Whereas if I don't pay him, with a little bit of legal fees, I now get 5 years of inexpensive leverage. And so that is what drives bad behavior. That is what causes the problem.
So I'm going to keep pushing for solutions to every problem that is being discussed. So the simple solution out here, according to you, is there should be a consequence of some sort. So for example, if you are a official somewhere and you have taken anti-person or you ruled against the person who's coming up before you 95% of the time because you think it is the right thing to do, eventually after the trial has lasted 7, 8, 9 years, the person in front of you has won 70% of the time, it should come in your ACR, if nothing else. That, boss, why did you clog up the legal system and waste the government's money for such a long period of time? That would be one way of doing it.
That's true. Not just that. The state should also be penalized. So let's think of it like, now this is not a new thing that I'm saying. All of us that watch American TV series would see if a cop arrests a criminal, he'll say, I'll sue you. There is no concept of suing the enforcement directorate in India for wrongful arrest. There is no consequence of suing a cop for wrongful arrest. There is no consequence of wrongful prosecution. It gives an unfair advantage to the wealthy and the powerful over the ones who are not, over normal guys who may be educated, who may be intelligent, but actually don't have the firepower. You are at a disadvantage in our system.
So coming back to that first thing then that we did, so this is how you are saying have some accountability for the government. How do you solve the problem of there being costless delays in the legal system for private parties? Does it come, I think in the book you suggest that increase the costs, right? Why the cost for a frivolous litigation, or if you've fought some matter out in court, why is the cost going to be 3,000 rupees or 10,000 rupees paid whatever battery of lawyers the other person's at?
Absolutely. So there are two stumbling blocks. And most of us, when we when you debate with policymakers and with lawyers, they'll tell you speed at which justice is delivered is very slow. And therefore, we need more courtrooms, we need more judges. Their response is basically increase the number of judges and courtrooms because you need a bigger volume to deal with this problem. We give no thought to, even if you create that, there is no consequence for being the bad guy. Now, think of it in the terms of the US. And I take the example of the US because it's an easier example to give. Many of us watch it in entertainment. Why does mediation work in the US and it doesn't work in India? Because the fear of losing a court battle is extreme. So you rather settle before. And if you say it is because of consequence, think in terms of India can never run Erin Brockovich. Because if somebody battles for 10 years, Tosh's liability will be 10 lakh rupees. It will never be 10,000 crores. Or even 2,000 crores. Think in terms of 2,000 crore penalties on a corporation that has been doing environmental damage. It will destroy that corporation, but it should. Because their waste management or their failure to sort of deal with environmental issues has cost people lives. And if we look at it, there are two elements to it. One is speed and one is consequence of not complying. And if there's little consequence of not complying, just speed will not be enough. Because like I gave you the 100 crore example, it may be 4 years of cheap debt. That will become 10 months of cheaper debt. So yes, the upside is less, but there is still an upside. Now, I should get hit in that example with not just the 100 crores, but let's say above the market interest. So 30% interest or 40% interest. Now I have fear. If I have the money, I will pay you back on time. I will settle on time. So there will something else that will happen that will speed up the process.
Okay, so consequences and people who are actually going to the court and litigating it. To speed up the system, one of the concepts then is, okay, how do you avoid this tariq pe tariq and adjournments? And I'm sure that creatively we can find a better solution than what happens right now. Because you started by saying the American system or the British system. In the American system, if they say your matter is going to be heard on the 25th of February at 11 a.m., your matter will be heard on the 25th of February at 11 a.m. Here, you could go to court that day. Your matter is coming up. Your number 38 in the High Court or number 40 in the Supreme Court may come up, may not come up. If it does, you're paying your lawyer to be out there. Matter doesn't come up, fine. Too bad, you're still paying the lawyer. If the matter comes up, you probably haven't told your lawyer, no, I don't waste money on you. It's number 38, nothing will happen. You seek an adjournment. Adjournments are given at the drop of a hat. I've seen lawyers seeking adjournments because mere chashme nahi kaam kar rahe hain, sort of a thing. So there has to be a way of fixing this. Why don't you have a fixed date and say your matter will be heard at this time? You don't come, too bad. Find another lawyer.
So part of the genesis of this problem is, let me sort of go back to a story from the past. So all lawyers in this room have heard of a constitutional authority called Mr. Sirvai. Sirvai has written these commentaries on constitutional. There's a critique. And the Supreme Court in one particular case decided to sort of put these sorts of timelines. That you will argue for one day, you will argue for this. So it's a batch case. So there are many lawyers appearing. So the court wanted to control the time in which the case would get done. Sirvai said, I want to challenge that ability of the court to impose a time on a lawyer because constitutionally you have a right to do so. So the court asked him, how long will it take for you to make that point? He said, it will take me 3 days to argue. And that put an end to any endeavor in the Indian court system because it starts from the top in trying to put hard timelines. The closest that we have ever gotten to sort of bring some discipline into how long lawyers would go on with arguments has been when we went to virtual courts, so online courts during COVID periods. Because in physical courtrooms, what happens is senior lawyers would go on and would badger the court. It's very hard to physically remove somebody from a courtroom, but it's very easy to press a button and switch off his video link. So this worked brilliantly in the COVID period. They just switch off. Once they had heard, they'll say last points. If he's continuing to make the same, they'll switch him off.
You know, with the greatest, I mean, I used to once anchor a show called The Big Fight, which had 3 people in real life standing out there. It is tough to get someone to shut up, but it's not impossible, right? And many of those people were politicians and relatively powerful politicians, but there's still ways of saying, "Bhai, bahut ho gaya hai, can you stop?" But you're saying once the hearing has started, my first fundamental question is, let's say there's a matter which has gone to court, or High Court, Supreme Court, any court. When is the matter actually going to be heard? It could be 5 years before the first hearing happens. Okay, I'm exaggerating, but you know what I mean. Because when the matter is listed, there may be no hearing that day. So once the argument has started, at least the car is moving, but the argument may not even have started.
So let's again think of why does this happen. Our court system, all of us would agree, is modeled on the British system. In the UK, this doesn't happen, incidentally. So they give time, they give dates, and they give how much time you have to argue. And it gets done in that time. There is a certain cultural discipline that exists over there. We have put in place a system with our culture. So it's trying to put in a circle in a square. So it doesn't fit quite well. Or sorry, the other way around, a square into a circle of the same size. We have put in place a system that does not culturally work for us. While in the big fight, you had some ability to manage what people were doing or saying. Here you have got people who have paid big money to continue to argue. And they're very senior guys. You also respect them for their knowledge and their know-how. So that drives the reticence of a court to sort of shut down. They do shut down lots of people, but very often it becomes hard to shut people down. Now, what happens if I give somebody 2 hours to argue and the guy goes on arguing? Sometimes he could make very interesting points and I could get interested. So I don't have self-discipline as a judge to say, all right, 2 hours, finish it. So it goes on. As a result, everybody else that has been given a time gets pushed back. But when it came to online courts, suddenly you'll find that this changed.
So technology is one way to fix it. But again, I'm coming back to this again to try and understand the concept. Okay, maybe give it an extra day. Maybe say that you will have not half an hour, you'll have 3 hours to argue. But the concept of a case coming up at a specific date, at a specific time, surely that is one reform that can be put in.
Absolutely. But culturally, we must be willing to work it. Culturally, we are not a people that are willing to work that. So we need a system that doesn't allow us that flexibility. So despite our culture, we are put in a box and you can't travel outside the box. So if you're outside the box, you can come back in. So
that technology, same cultural argument that doesn't allow you to drive on the streets of any city because culturally I don't feel I should drive in the same lane, right? I must be in 8 people in one lane. But culturally, we're able to do it if we go to America or we go to Dubai, right? Then suddenly everyone's driving in their lanes.
So I'm back to consequence. We have very low consequence. So when we drive on the wrong side, when a cop, first you start arguing with the cop, then you threaten to beat him.
Now say, "Jante ho mera baap kaun hai?"
Absolutely. This doesn't happen in America because it's such a, "Baap kaun hai, you please come with me, sir."
So we have to find a way of fixing this in some form or the other, which presumably can happen. You have suggested technology, right? You often mention that technology is something that can be used to actually get this thing going. virtual courts, other things. You may not need to argue that much if briefs are prepared by AI, for example. A lot of the basic stuff is done. Batch cases are being put together and saying, but we've already decided this. Why are you wasting our time?
Technology is part of the solution, but there are a bunch of other things that need to happen. So if we move from the mindset of judges or the state being a sovereign authority and above the law, I've heard one particular Supreme Court judge very often would say that above us is only God. So once you lose that attitude and you come in as a service provider, now you will see how to bring in the service provider mindset is to bring in active performance evaluation. You can bring in remuneration wise, you can use remuneration or bonuses. It works for rest of the world. Why should the same thing not apply to judges? Ultimately, they also say we are in service of the people. So then lose the sovereignty bit.
Let's now start looking at other solutions. Let's begin with corporate law, which I know there's a lot of suggestions and ideas you've got. How do you make contracts enforceable? How do you make sure that people believe in the rule of law? Because at the end of the day, if you're attracting investors, you're telling everyone, come to India, this is the fastest growing economy. People need to know that there is the recourse to the rule of law at some point. So some of the suggestions you would make.
So very often when we say there is no ease of doing business in India, the focus is very often on government regulation and compliance and how it's hard to deal with. But also think in terms of what happens when you deal with between private parties. So if you have a contract between two, and you will also notice that when your small little contracts are okay to do, but when you get into large contracts, particularly, you will find that people very happily violate. Now, at a personal level, what you will encounter is if somebody is supposed to give you, say, 30,000 rupees, they will not give you on the date that they are meant to give you very often. There'll be some delays, they'll give you some excuse. And because that is the culture that prevails, you will then subject somebody below you. When you have to pay somebody, you will say, my cash flow is getting affected. I'll be stupid to pay somebody else on time. Now, then think of it at a larger scale. This is how our contracts work. This is the sanctity of contract bit. One of the big obstacles for ease of doing business is very low sanctity of contract in India. That is because it's not just the speed at which you can enforce contracts, it's also the consequence for the breaching party, because like I was explaining, we actually incentivize breach and ask most serious business people that run large businesses, and everybody will tell you that's true.
Okay, so coming back to this entire question of speeding it up, now there are two things that has to happen. You're right, a lot of volume of cases will always be there. One issue is the pendency of the number of cases that is right now, and the second is the flow of the cases that is entering the system, and certainly going up to the higher judiciary, the high courts and the Supreme Courts. On the flow part of it, the question about the appeals is something which I've heard many people saying, maybe there should be a restriction, maybe there should be some controls. How do you control that process? Or you said that you can only appeal, twice or three times. You can't go all the way up.
So they are all right. So everybody that makes that point are all correct when they make that point. They are partly behavioral issues, partly they are constitutional issues. So I suggest, for example, splitting the Supreme Court into a federal court of appeals versus a pure constitutional court which deals only with constitutional issues. You will not get into anything else. Now, what happens is, over a period, when I joined the Supreme Court as a young kid, the Supreme Court dismissed most what is called special leave petitions because it's not really an appeal. It's a petition that says, allow me to appeal to you. And the behavior in the lower courts is driven by this behavior in the Supreme Court. Today, if you look at the number of special leave petitions that go to the Supreme Court and how many of them get heard like they were appeals, our Supreme Court, which is meant to be principally an interpreter of statute and constitution, now deals with factual determination, which should never happen. Therefore, effectively, you're converted yourself from a constitutional court to a court of appeals.
The Supreme Court is hearing bail cases on a daily basis, and that's at a time when there should be a simple jurisprudence that other than ABC cases, you should give the person bail. But the lower courts don't do it. They kick it up to the higher court, then it comes into the Supreme Court. Matters of liberty, the Supreme Court pays its attention to that.
Absolutely. And so when you say that, you are actually touching upon the core of the whole need for an appeal system of this kind. Why does the Supreme Court so happily hear these appeals? It is because the confidence in the high courts have fallen. The high courts, the confidence in the lower courts have fallen. Why has the confidence fallen? Because the quality of the human being that is manning that position has lowered. And part of our issue is, how do I not just improve speed, but how do I improve the system qualitatively? So that qualitatively you begin to trust you, there's greater acceptability for a decision that somebody in a lower court has taken. And that will very quickly deal with the sort of it's not multiplicity of appeals, it is how many of the appeals actually get heard in a detailed fashion. It's because lack of trust in the lower court.
So, is it time then to also start thinking if you want to speed things up? And yes, there are lots of matters coming up. In addition to technology, to start, some of the discretion perhaps can be reduced a little bit. What constitutes acceptable, freedom of speech? Now, okay, you can say it's very difficult to codify it. But when someone should get bail and when someone should not get bail, the same matter going before 20 different benches, we may well have completely different results, including different benches of the Supreme Court. It'll have very different results. So is it time to perhaps codify it, reduce the discretion and saying, look, A, B, C, give the person bail. Now, the Supreme Court is not having to step in to decide every time someone is arrested in the country to decide whether this is a matter where it should have bail or not.
So something that we spoke about earlier in the conversation, how easy is it to get an injunction? The reason why it's easy to get an injunction is because there are no terms on which the injunction is granted. So if an injunction is found to be unfair, there is no financial consequence for you. That is part of our problem. And that goes to, if you look at textbook, it will tell you that those conditions have to be satisfied for you to grant an injunction. You look at most injunctions that get granted in our country, nobody looks at those conditions. So they need to, so in the book I suggest statutory changes. So for judges to grant injunctions, there should be a challenge. I also suggest the creation of a know-how database. Qualitatively, and why I say trust in a lower court judge is not only about the integrity of the judge, it's also about the caliber of the judge, intellectual caliber, his capability to take decisions correctly. So what you see is the general sense that you have that a district judge must have lesser knowledge than a high court judge, and a Supreme Court judge is just below God. So he's basically all-knowing, all-pervasive. That should not be the case. We need to have a system where even when you go to a district judge, that the judge delivers very high quality justice. And therefore the appeals become harder. And if you see, again, I go back to the West, if you look at the developed countries, the judges at the lower levels are very high quality. And therefore there's a quality issue. If we lack in quality, what can we systematically do to improve quality?
So fixing quality is one of those things which is very tough to say how long that will take to fix quality. So the other way of doing it is have a certain very clear-cut guidelines that are really codified and laid out in very, very clear terms. Do A, B. AI will eventually come and do it, I guess, at some point. But you specify a very clear algorithm for all judges to follow. If A, B, C, D, E, F, G, H, I, J grant bail, if X, Y, Z do not grant bail. Similarly with injunctions, similarly with other rulings. So if that is codified to a greater extent, perhaps it reduces discretion, and paradoxically, then you're not worrying about quality that much.
For many kinds of instances like that, we do have these rules. Everybody sidesteps those rules. So it's a matter of convenience. And as I go back, there is no consequence of sidestepping. There is no impact on your career if you do that regularly as a judge. And therefore, we are set up to sort of get bad outcomes. We need to look at the core issues. They are human issues. They are quality issues that we do not seem to address. We seem to suggest that all human beings are similar. Now, let me tell you my experience dealing with international lawyers. And I say that use that same when you come to Indian courts. Lots of international firms, you'll find that the lawyers on a one-on-one basis are fairly average in intellect. However, what they turn around in work product terms is very high quality. They are punching way above their weight. So what is it that they have done? And it will therefore not take very long to fix quality. What they have done is they have created know-how systems and training systems. You are trained how to use the know-how. You don't need to know the know-how fully. As a result, what they churn out to you is very high quality. We can very easily, this is coming, again, it's legal services that these lawyers are delivering. It is to clients. As a judge, you can use the same principle. How do you create a system? How do you train people to use the system? And how can they deliver similar high quality outcomes?
That's the same technological answers to some of this stuff.
It is.
Looking at another couple of big bang sort of things, how do you remove and reduce the pendency? Now, over the course of the last few months asking people for radical seditions. A couple of radical seditions have come. One being a one-time scheme where, given that 60-70% of all cases which are pending right now are government cases, you actually ask every government department, you set up a Pradhan Mantri Speedy Justice Scheme or some sort of the other, and you say every government department has to look at all of its pending cases, find the weakest 50%. There's a In every department there's a person who will vet it once to make sure there's no corruption, but the weakest 50% of your cases you are instructed to close in 2 weeks. That theoretically removes 30 to 40% of your pendency.
Oh, yes. In theory, it should. The reason why I don't get into that territory is I have no confidence in something like that. Because there is a question of who's going to do that review, what is the integrity of the person that does the review, how sustainable will somebody in the future look back at that review to say, was there something wrong? What? And
But if it's a scheme, you could do it, right? So I understand no person in the government today will ever take back an appeal or say, I'm shutting this case or I'm not holding a person guilty because you're scared of vigilance. But if you're given instructions, what are your 50% of your weakest cases presented to the next level for clearance? Fine, you're doing it as part of a scheme, and then there's a system of immunity built into it, and you are having a level of cross-checking to make sure that that person didn't take a bribe.
So when we think in terms of schemes of that nature, when we think in terms of tax, because that's where it's very prevalent, tax is a settlement. Here we are talking about withdrawing those appeals or cases. It's a very different thing to withdraw. There is then an acceptance of, in some ways, that, let's say it's a minor motor vehicle offense. So the question is, why is a motor vehicle offense going on for 5 years or 10 years? If you withdraw that case, the question that you'll always ask is, was it right to jump the red light? And all I need to do is jump the red light and make sure my case doesn't get done for the next 5 years. And we maneuver. Let's not delude ourselves into this romantic idea that we culturally don't do this maneuvering. We'll do it. So once it is done in one way, we will then sabotage the system. So yes, in theory, as in concept, withdrawal or doing that sort of striking off of these useless cases, a very good
So
idea.
it's a but then the fact is, whose fault is it? If it's the person whom you're going after, and that person has been delaying the trial or delaying the investigation or delaying the questioning of what happened in that accident or that motor vehicle case that happened, that cannot be closed then because it is that person's fault. But if it was the department's own, we couldn't figure it out. There's no evidence one way or the other as to ye galti kiski hai, does not make sense to proceed, then that's a matter which you are relatively not likely to be able to proceed in.
I would say a scheme would help with something like that. It's not as if you can't do it in today's legal architecture. You can do the same thing today. Is that
Except that nobody will have the courage to do it because they'll say, why? Somebody will come and say, तुमने क्यों वो देखो accident हुआ था, तुमने उनको क्यों जाने?
So the beauty of our court system today, and there are various things including performance review, sovereign immunity, etc. Beauty of our system is our courts will then question the scheme itself. So somebody will challenge the scheme as being unconstitutional. If you remember, even the income tax settlement schemes are challenged. So somebody challenges it, and there is that risk never really goes away. And the way our system currently works, and which is why I say, with the existing system, when we think of ideas like this or solutions like this, they are always fraught with risk. That risk never goes away because you can come up with a scheme, but if our basic system continues to be what it is, you will today drop the number of cases. 5 years down, somebody will say the scheme is not binding. The court can review whether the scheme is legitimate or not. I believe that the scheme is not legitimate.
Send the scheme to the Supreme Court on day one and say, please have hearings in the next 2 weeks and decide on this one way or the other.
True it.
Another radical idea, for example, is that if you look at their new criminal laws that have come up, and there were 3 of them which are supposed to make changes, they are talking very clearly about time-bound justice, which is an important part of it. But it's not crystal clear whether, what happens if those times are being expanded. Is it not time for us to think about a formal statute of limitations across the board for all crimes, where you're saying that you have an FIR if you have not been able to bring a charge sheet in 3 years or 4 years, and the matter just goes away. If after that the matter is not brought to trial within 1 year, 2 years, the matter should go away. There has to be a limit. You should not be having 20, 30 years before matters are being decided.
No, that's true. So it is when a case is brought against somebody for a 20, 30-year-old sort of You have to see what is the seriousness of that offense before you can allow it to happen. In some ways, it already exists. But coming to putting timelines within, statutorily, putting timelines within some dispute needs to be resolved. So let's take the case of Insolvency Act. The Insolvency Act said in 180 days, you need to get the insolvency proceeding done, extendable by 90 days, so 270 days. And after that, the company, if you still don't have insolvency, you must go to liquidation. Is the scheme of the act. Not too many companies have gone to liquidation. And insolvency proceedings have been running for 400, 500 days. Forget about 270. Today, nobody looks at those limits of 180 days or 270 days with any degree of seriousness. And that's an experience that we should learn from. That is how we culturally behave. That because it also is, there is no consequence. A judge will say that there is no consequence. DK, you've got 270 days. I don't really care. Are you going to remove me from my chair?
So the question of consequence really comes through, and I am going to now throw it open to the room to take questions. But before I do that, I'm going to just have a quick rapid fire round, right? One word or one line answers to all of this. In one word, how would you describe the Indian judicial system today?
Dysfunctional.
If one reform you would sign into law tomorrow morning if you were given full powers, one reform.
Online courts.
The clause in commercial contracts that founders almost never carefully read through. And they should.
Big damages for violation.
Most underrated quality in a really good lawyer, is it patience or courage or curiosity?
Courage.
One thing foreign investors ask you in private that they never say in public or on a stage like this.
How effective is your legal system?
Don't say that publicly. I thought they would. Okay, the most hopeful thing you've seen inside an Indian courtroom in recent years?
There are actually lots of judges out there that sincerely try and do a great job of whatever they can. They are subject to the same constraints that many of us are.
One country whose judicial reforms India should look at and perhaps learn from.
Now, that's a challenging one, but I can say the one country, not in terms of judicial reforms, but the one country that it can look at in terms of how we might want to model our system is the United States, because the US looks a lot at consequence for something not happening.
I'm thinking about that particular answer right now and how the American legal system is functioning and what consequences the President of the United States has for a lot of the things that he's saying and doing. So, okay, I'll park that. I would have been inclined to entirely agree with you maybe a year ago. Today, I'm not that 100% sure. So, on that rare note of disagreement, we will maybe start taking questions from the rest of the room.
I have a very simple non-lawyer question because I'm not a lawyer. Is that as taxpayers in this country, do we have right to clean air? Is that something that is legally available? And if we do not get that, despite paying taxes, then what can we do as citizens?
So you have a right to life and liberty constitutionally. Right to life and liberty include the right to clean air. And most people say that. So to answer your question, yes, but the right is being violated. What are your solutions? In democracy, they will say vote in the right government, or it will say go to a court and challenge your right to, or try and enforce your right to life. The underlying problems are that the one thing that we need to realize and accept is that judges can't pass orders and bring cure to you. These are administrative tasks. These are not sitting on a bench. There's a limit to what you can or cannot do. And that needs to be taken into account. So it's really a governance issue as against a right issue, because in terms of right, you are absolutely right, the right is there. But how are you going to enforce it is where the challenge is, and you can't. Practically, you will run around. So you'll see now the Supreme Court is sitting around with this. It'll pass a few orders here or there. You look at the Diwali crackers. They've been banned for a long time. Every Diwali, you see non-stop crackers going. So there is a limit to what courts can do with orders. And it is really a governance issue. The people must want it. And governance, you must also vote for something like that. And that's really how democracies work. That's the system that we have chosen. So if it doesn't work, we have no other option but to be frustrated about it deeply or look to relocate to other places, because the answer will come only through governance.
Right. Lots of hands going up.
Hi, Mr. Prasad. My name is Varun Bajaj. I run my own law firm, and I'm the senior vice president at Self, working on the policy of opening up of the legal market. I think one very interesting fact which I find in your journey, I think many young lawyers would want to know. You're amongst the few lawyers who have dabbled with law and polity both. Is I've always been intrigued about, and I think probably the only one who's actually been founder of a very big law firm and then dabbled with polity, because most of the examples which we see in the Indian legal sector are litigators entering polity. So I think nobody comes to my mind except you, who has tried both and has seen a journey curve. A lot of young lawyers dabbling with law and polity. What would you advise them? Is a law firm come polity a good model, or the typical litigated polity model is the way to grow? Because I think you have dimensions, you have seen both the curve. So your input will be very valuable for young lawyers.
So I've never really thought in terms of that I might be the only one out there. It's also that commercial law as a practice is a very recent phenomenon in India. Litigation has always been around. But if you look at older democracies where you have had commercial law being practiced for a lot of time, so whether it is the UK or the US, you'll see a lot of lawyers move from firms to politics and then move back. So that acceptability is a lot more in those systems. I'm sure, I mean, ours is a young profession as corporate lawyers, but as the profession becomes older, there will be more and more people, because as you practice corporate law, you do acutely realize what's not working in the commercial space. And then the question is, do you just wait around for somebody else to do something, or do you take a shot at it yourself?
Firstly, thank you so much for a wonderful discussion, very insightful, completely agree with the points. On the question of consequence, I'm just thinking, is it something a little bit more deeper? So if I take the example, for instance, of liquidated damages, I used to work at Trilegal at some time back, and, we used to tell our clients that, look, you can decide as parties to the contract, whatever, right? If there's a breach of contract, you pay X. But the court will come in and say that, we don't care what you've decided as parties. We will tell you what is the right damage. Now here's a situation where the parties themselves are determining what the consequence is. But the court is saying, you know what, I don't care. So you alluded to this, Anand, when you said that, the mentality of a service provider. So apart from consequence, how do we get judges or courts? What do you think is the solution to get them to start thinking on the lines that, hey, we are not, the it word for this?
So here when I say consequence, it's consequence for the decision maker away, not for the contracting parties. It is when the decision maker has no consequence, they will say, I do it out of the goodness of my heart. I'm doing the best decision possible. The question is, if your best decision turns out to be bad, should there be a consequence for you or not? And I would venture to say that it is now time for us to move away from that imperial legacy to say that there should be consequence. Various countries do not have that sort of imperial legacy protection. I'll go back to the US. I mean, the US has become increasingly, since the last 1 year, a bad word. But they are a model that we could look to follow. The one thing that we should be careful of when we think of all of these things is that divinity has not created a perfect world. Don't chase perfection. Try and chase something that is better than you. There is no doubt that an American citizen is more empowered than an Indian citizen. And therefore, we can easily at least aspire to be there. If we start finding holes over there and say that's why we should not change, that is an argument for status quo.
Anand, thank you so much for having been with us. It's really, really fascinating. And let's hope that this one crucial area of pending reform is actually something where we see a lot of action in the next year or two.
Thank you, Vikram. It was enjoyable. Thank you.